Next case versus United States. I may cover two cases today. I cover two cases today that will be back on track in terms of the syllabus cases. We'll see if we can get through two. So Whren is a famous case because it's a controversial case because a lot of people say that it's been used to justify racial profiling. So it's a controversial opinion. So the police stop a motorist under the Fourth Amendment if they have probable cause to believe there's been some kind of minor traffic violation. They call it a civil traffic violation. And the Supreme Court said yes. As long as you have probable cause to stop a car and search the car or to stop the car, you can, no matter how minor the traffic violation is, you can do that. So this involves five squad officers are in plain clothes. They were patrolling in a quote high drug area in an unmarked car. And so a dark Pathfinder, which I think is a Toyota truck, with temporary license plates, and two young black occupants were waiting at a stop sign. And they said that the car, or the Pathfinder, remained at the stop sign for an unusually long time, like more than 20 seconds. So that piqued the officers' attention. The unmarked car, police, they engaged in a U-turn. So they drove back towards the Pathfinder, and then they said the Pathfinder suddenly turned right at the stop sign, but didn't signal, and then sped off. So the not signaling at a stop sign is a minor civil traffic offense. They said the Pathfinder, turned right without signaling at an unusual speed or an unreasonable speed. Means that they thought the Pathfinder was going faster than normal, whatever that means. So the Pathfinder was stopped at a traffic light, and they caught up with the Pathfinder. They pulled alongside the Pathfinder, and then one of the officers got out of the unmarked car. He approached the driver's side of the door, and the driver's name was Brown. Whren was in the passenger seat. He told Brown to put the car in park, and when the officer Soto walked up to the car, he could see inside the car, and he saw Whren in the passenger seat holding two bags, what appeared to be crack cocaine. So that gives him probable cause that the drug crime has occurred. So Whren and Brown were arrested. And the car was searched and they found other drugs. And so they were indicted on federal narcotics charges. Now, Whren and Brown says that the reason they were stopped was because they were young black men in in an area known for drug transactions. That's the reason the police did a U-turn and come back around to take a look at them. And then they turned right without signaling, which was a very minor traffic offense. So, talked about this a lot. So whenever you have your pre-trial motions, if you're a defendant, you try to suppress the evidence. So they filed a motion to suppress the evidence, saying that the stop was illegal. Stop was illegal, and so search. So basically the defense was saying that the sole reason for the stop wasn't because they had reasonable suspicion or even probable cause, but Officer Soto, the reason for stopping his car was pretextual. Pretextual reason is a made-up reason doing something that's not legal. And so the defendants, Brown and Whren, are arguing that the pretextual reason for stopping the car is because they were two young black men driving a Pathfinder in an area known to sell drugs. The district court, so it's federal drug charges. So U.S. District Court is the trial court of the federal court system. So the district court said the facts are not in dispute, and they upheld the stop, saying that the officers conducted a normal traffic stop. So the motion to suppress was denied. They were convicted of the drug crimes, and then that's appealed to the appellate court. And since this was in Washington, D.C., where it happened, the Court of Appeals in Washington, D.C. is called the United States Court of Appeals for the District of Columbia, or the D.C. Circuit. Because all the courts of appeals at the federal level are called circuits. Like we're in the Fifth Circuit here, Texas, Louisiana, Mississippi. The DC Circuit has its own circuit because DC is the capital, so there's a lot of important cases that happen in the capital in DC. So they have enough cases just so that DC is a very small geographical area, but they have a lot of cases, so they have the circuit named the DC Circuit. In any event, the DC Circuit affirms the U.S. District Court for the District of Columbia. So the DC Circuit said that once the officers once they had, they said a reasonable officer in that same situation that Officer Soto was in could have stopped the car for a suspected traffic violation, even if they reason they stopped the car was because the people in the car were African Americans. In other words, it doesn't matter what the officer's subjective motivation was for stopping the car, as long as they have an objective, reasonable basis to stop the car, which is ran, you didn't run, you turned right at a stop sign without signaling. That's an objective basis for a traffic stop in and of itself. Doesn't matter who's driving. Uh, Even if the reason you stop the car is because you think these two African American not occupants, people in the car were engaged in some other kind of criminal activity. So it goes to the Supreme Court, and Justice Scalia writes the opinion. When Justice Scalia writes an opinion, it's going to probably go for the police. Because Justice Scalia was a conservative justice appointed by Ronald Reagan, and Reagan's appointments to the court were uh, conservative. So Scalia says even a temporary stop is a Fourth Amendment seizure. Anytime you're stopped, that's a seizure. So even just a brief stop is a seizure under the Fourth Amendment. And he said, well, the defendants are arguing here because it's a civil traffic violation. It's such a minor traffic violation that you ought to have more proof of probable cause because cars are ubiquitous in society. They're used everywhere to go anywhere and everywhere in America. You drive a car, and the police will always be able to find some small technical traffic violation that you committed to stop the car. So you should require more than probable cause because you can always find some kind of technical violation. And because you can always find some kind of technical violation, or you can even create one and lie about it, that uh, essentially you can always make traffic stops for pretextual reasons. You come up, uh, you can say there was a traffic violation, very small violation, but the real reason you stopped the car is because the occupants were, in this case, African Americans. Even though there's no suspicion or probable cause that existed, there's a temptation uh, to engage in racial profiling. That's the accusation. So the defendants, Whren and Brown in this case, they want the court to adopt a separate test, not probable cause, if the traffic violation is very minor violation. It's a civil traffic violation, which means it's a minor violation. They want the Supreme Court to come up with a different test. It should be, would an ordinary reasonable police officer have done the same thing? Would an ordinary reasonable police officer acting reasonably, would they have made that traffic stop for the reason given? Like if somebody is stopped at a stop sign for 20 seconds and turns right without signaling, would an ordinary reasonable officer have done that? That's what the defendants want the Supreme Court to decide. They want the Supreme Court to rule based on that question. because the defendants are saying the police are using ulterior motives to make a vehicle stop. In other words, the real reason the stop was made, not because they didn't signal at the stop sign and turn right. The real reason was that they were stopping black vehicle occupants in a high crime, a high drug area because they were black, not because they turned right without signaling. That's their ulterior motives, or that's the pretextual reason they're giving that they're using, even though they're saying they pulled the car over because they failed to give failed to use their turn signals. So the court here is Justice Scalia. He's saying that it doesn't matter what the police subjective reasons were for making the stop. The police can make the stop if they have any reason for making the stop, if they can show there is an objective reason for making the stop. And the objective reason for making the stop is that if there's any traffic violation that occurs, you can make a stop. It doesn't matter that the real reason you made the stop was because there were two black young men in the car. But in this case, they had an objective reason to make the stop because they committed a small traffic violation by turning right at the stop sign without signaling. So, an officer's subjective motives for why the real reason they made the stop never invalidates if there's an objectively justifiable behavior under the Fourth Amendment for making the stop. So it's not their subjective motivations for why they made the stop. If they have an objective reason to make the stop, if there's any kind of traffic violation, you can make the stop. It doesn't really matter. The reason you made the stop was not for the traffic violation, but because the people were of a different race or racial profiling, essentially. That the objective reason for making the stop is enough, is legally enough, doesn't violate the Fourth Amendment, as long as, regardless of what your subjective reasoning was. So he says that if your argument is racial profiling, then the way to attack that under the Constitution is through the 14th Amendment, not the Fourth Amendment. 14th Amendment has an equal protection clause, which says that if you have people of two different races, you have to treat those people equally. You can't treat one group of people differently than another. So if you're going to argue that the police are engaged in racial profiling, you have to do that under the 14th Amendment as an equal protection violation, not under the Fourth Amendment, because the standard under the Fourth Amendment is subjective reasonableness. So he's saying that the lawyers are arguing intentional race discrimination under the Fourth Amendment. That's the wrong amendment to be arguing intentional race discrimination. 14th Amendment, Equal Protection Clause, is where you argue intentional race discrimination. The Fourth Amendment just prohibits unreasonable searches and seizures. It doesn't say anything about treating people equally. So, in the Fourth Amendment context, unreasonable search and seizures, whatever your subjective reasons for making the stop, doesn't matter as long as you have an objective reason that a traffic violation has occurred. If you have an objective reason that a traffic violation has occurred, it doesn't matter your subjective intentions for why you made the stop. So that he rejects what the defendants want. The defendants want that basic police practice. An ordinary reasonable police officer would have done what they did. An ordinary reasonable police officer would have made this stop uh, if the officer had the proper state of mind to make the stop. He said that's not the Fourth Amendment analysis. The Fourth Amendment analysis is subjective reasonableness. It has nothing to do with their subjective intentions. So since the defendants want the court to conduct a balancing test, and they're refusing to do that. If the balance would be, what's the benefit to society for police to enforce civil traffic laws against the intrusion of the Fourth Amendment, the intrusion on individuals having their Fourth Amendment rights intruded upon? And he said, well, we don't do a balancing test as long as you have an objective, reasonable basis for making the stop. So he rejects the balancing test argument. So as long as you have an objective reason to make the stop, it doesn't matter what you're thinking in your mind about why you want to stop these people. And in the book, there's a footnote of another case called Arkansas versus Sullivan. Whren was decided in 1996, and this Arkansas versus Sullivan case was decided in 2001. All this does is Arkansas versus Sullivan extends Whren to a full custodial arrest. In other words, if you have probable cause to make a full custodial arrest or to make a civil traffic stop, that's Whren. The custodial arrest is Arkansas v. Sullivan. Then you can, as long as you have an objective reason to arrest somebody, you can do that regardless of the real reason you're doing that is because of race, for example, or gender. So Wren's a very controversial decision because a lot of people says that Whren is really a test for, or Whren opens the door to allow people to engage, police to engage in racial profiling. But the court sidesteps that issue here and says, as long as you have an objective reason to make the stop's permissible, regardless of what you're thinking about why you want to make the stop.